Thank you.
Mr Chairman.
I call the Honourable Philip Goff.
Mr Chairman, I want to pick up a couple of the points that the Minister, Chester Borrows, has just made, and he repeats the justification for a bill which in the end could not be justified. That's why when we look at Part 2 of the bill, as in Part 1, page after page of the bill is struck out. Even the title, Sustainability, is struck out. And can I suggest, Mr Chairman, that the reason that the word sustainability has been struck out is because what the national government was proposing in terms of fairness, in terms of decency, in terms of having a justice system that actually deserves that title, there wasn't anything that was sustainable in the original bill if you judge it on the basis of those particular principles. The Minister talks about the blowout, he terms it, in legal aid. What the Minister doesn't tell the House is that before legal aid was increased under the last government, it had been static for 20 years. Legal aid had not been increased in 20 years, and of course it was going to cost more when you decided that actually if the principle of legal aid, affording justice to all, is to be realised, then you cannot make the threshold level for being eligible for legal aid as low as it is. And the threshold, it will surprise listeners to hear, for a single person getting legal aid is a salary of $22,000 a year. That, Mr Chairman, is less than what you get on the minimum wage. So effectively what we had, and what this government was seeking to worsen, was a situation where if you were on the lowest level of society, if you were on a benefit, you could get legal aid, but if you're out there working every hour that you're able to get to try to get things together for your family, you would be rendered ineligible for legal aid because the threshold was, you meaning the person that's receiving it, Mr Chairman, because they were not so poverty-stricken that they would get it. Now, what this government seems to be saying in this part of the bill and in the bill as a whole is that if you are absolutely poverty-stricken, then you might get some assistance, but they ignore the fact that for a great many people, ordinary, hard-working New Zealanders trying to get justice through the system, you'll get no assistance because the threshold levels are so low, and you'll be denied the right to justice. And there are tens of thousands of New Zealanders that come into that category. So when the Minister talks about, as he did, blowout of legal aid, what he's effectively saying was an extension of legal aid so that people who could not reasonably be expected to pay for the cost of justice themselves would not be denied justice. And one of the basic principles by which you judge any society is that access for justice should not be on the amount of money you earn. And what this section of the bill shows more than anything is that ministers on more than $250,000 a year don't understand what it's like for people on $30,000, $40,000, $50,000 a year when they're confronted with the huge cost of legal bills. They can't afford it, they don't get represented, and justice doesn't get done. And, you know, surely there would be bipartisan agreement in this House that a priority must be that nobody is denied justice by virtue of their inability to pay. But the tragic reality of the system in New Zealand, worsened by this bill, is that time and again people are denied access to justice. Justice is for the rich, justice is for those that can afford the QCs, and those who can afford the QCs end up getting away with things that probably they shouldn't get, and those people at the bottom that are struggling to see justice done are denied justice by this government. And I refuse to believe that this is about the fact that the government can't afford to pay for it. The government could afford to give John Key a couple of $100,000 a year in tax cuts. Surely they can afford to ensure justice for people, and in this clause of the bill, surely they can afford to give justice to the child who might otherwise be unrepresented. The child, the most vulnerable person in the system, if they need counsel for the child, that means that their life has been pretty miserable. They've had a hard go of it. Mr. Chairman, they do deserve justice. And this bill constantly, in every clause that was put into it by Simon Power, denied people justice. Now, you know, if you look at the report back and the summary from the Select Committee, you will see how appallingly bad this legislation was when it was introduced. So appallingly bad that a new minister coming in could not sustain it, particularly one with leadership ambitions, trying to take away the flinty-faced image that she had. She realised that this was poison to her, and particularly poison to her when you are denying justice to children. But she hasn't realised it very effectively, because this is the second bill that we've had in the House this afternoon that has sought to take away the rights of representation that children can have. And I think that Mr. Chairman, is an absolute disgrace. This legislation has been gutted of about, you know, maybe 70% of the appalling original clauses that it had in it. And what I'm saying to the House today, Mr. Chairman, is that the remaining 40% isn't worth the paper that it's printed on either. There are, you know, when you look at it, there are so many extra procedural things that the court will have to go through. This won't be saving money. This will be costing money. This becomes a bureaucratic nightmare when you work out what the interests of justice involve and where there is serious hardship, all for the saving of $50 as a fee on legal aid, or for trying to force the parents under Clause 2 to pay the cost of counsel for the child. And there'll be battles between the parents who may be at odds with each other. And in the end, for the sake of saving a little bit of cash up front, there'll be huge administrative costs, and the child runs the risk of not seeing justice done in his or her case. Mr. Chairman, the regulatory impact analysis of this bill and applying to Part 2 says the purpose of the legal aid scheme is to provide access to justice by providing legal services to people of insufficient means. It contributes to fairer outcomes by ensuring that parties with unequal financial resources have equal access to justice. Consequently, legal aid helps underpin confidence in the justice system. That is the government's own regulatory impact statement. And I want the new minister in the chair to explain how in any way Part 2 of this bill, or for that matter Part 1, meets the objectives that are set out in the regulatory impact statement. How is it that this bill helps provide access to justice? The whole purpose of this bill is to deny access to justice. It's to deny access to justice to save money. There are many areas where the government could be saving money without denying access to justice, and particularly without the punitive areas that are involved with changes to the Care of Child Act that are made in Part 2 of this bill. Mr. Speaker, the Minister, under pressure and under the pressure of submissions that were made to the Select Committee, has tried to make this bill acceptable. She has taken out some of the worst features of it, but she has equally left features that render this bill unacceptable to our side of the House. The Clause 21, which the Minister previously in the chair said the paramount principle of the care of the Child's Act was the best interests of the child, and that's because it was in the Principal Act. It didn't need to be in Part 2 of this Act. That's not a very good reason, Mr. Speaker, because it's abundantly apparent that when you are charging for counsel for the child and putting obstacles in the way that this bill does and the previous bill that the House has just considered, you are not acting in the best interests. You meaning the generic you, Mr. Chairman. I'm sure that you would want to see the best interests of the child protected in this Act. You're a very good chair and member of the House. We are interested in upholding what every New Zealander believes should be upheld, that the interests of the child should be paramount. So why is it that this bill is so miserable in making the cutbacks that it does in this area?
Scott Simpson.
Very interesting always to follow the